right, good afternoon, everyone. We're going to get started. My name is Andrea Cornell, and I am the Public Policy Program Assistant at Genetic Alliance. I want to welcome you to this Coalition for Genetic Fairness and Genetic Alliance webinar on the implementation of the employment provisions, or Title II, of the Genetic Information Non-Discrimination Act. Today's program was largely inspired by the February 25, 2009 release of a Notice of Proposed Rulemaking from the Equal Employment Opportunity Commission. The proposed regulation applies to Title II of GINA, which is the portion of the law that protects individuals from genetic information discrimination in employment settings. With the release of the proposed regulation for Title II of GINA, the EEOC opened a 60-day comment period that allows the public to provide input on both the proposed rule and any of the issues related to the proposal. So during today's program, Susanna Baruch, Law and Policy Director of the Genetics and Public Policy Center, and Jeremy Gruber, President and Executive Director of the Council for Responsible Genetics, will present model comments crafted in response to the EEOC Notice of Proposed Rulemaking. Through this process, they will discuss the protections afforded by GINA and greatly illuminate areas of confusion and issues that require additional attention as we move toward implementing this landmark law. Susanna will begin the webinar with a discussion of the important definitions within GINA, as well as the interaction between Title I and Title II, among other topics. Jeremy will then discuss more specific issues addressed in the model comments. We will have ample time at the end of the program for questions and answers from the group. I'm very happy to provide you with this timely and educational webinar on such an exciting issue. With that, I will turn it over to Susanna to begin our discussion.
Thank you very much, Andrea. Hello, everybody. I want to thank the Genetic Alliance for putting this webinar together. As most of you probably already know, we are in the middle of a long process of getting the regulations related to the Genetic Information Non-Discrimination Act in place. The last time that we did a webinar with the Genetic Alliance, it was to discuss a request for information that the agencies regulating the health insurance portion of GINA were putting together. The RFI was an effort to get information together that would then go into a rule from those agencies. Today we are talking about Title II of GINA. As Andrea said, the EEOC has actually already issued a Notice of Proposed Rulemaking, which is essentially a draft rule that lays out the regulations for employers to follow in complying with GINA. So what Jeremy and I are going to do is talk through the draft comments that we have put together. These are comments which other organizations and individuals are welcome to use as the basis of their own comments. We encourage everybody who's interested in this topic to submit comments. The draft comments are available on the Genetic Alliance website. They're also available on the Genetics and Public Policy Center website, which is dnapolicy.org. And any questions that don't get answered today, feel free to email me or Jeremy with questions directly. We will be putting together the final version of these comments for our own submission by May 1st, which is the deadline. So with that, I want to talk on the first slide about the sort of three main areas of the proposed rule where we think some additional attention needs to be paid. To back up for a minute, I think it's fair to say that there are many areas of the proposed rule where we are very pleased with the approach that EEOC took, a very thoughtful and thorough approach, which basically takes GINA and applies other areas of employment law and sort of vice versa. So GINA makes some changes to some areas of employment law. GINA is also consistent with other areas of employment law, and the EEOC has done a good job of sort of digging in to figure out where there are new issues that need to be addressed in this proposed rule. The three areas that we emphasize in our proposed, in our draft comments are the need for an emphasis on strong and unambiguous definitions of some of the key terms in the law, which are new terms for those dealing with in employment law. Terms like genetic information, genetic test, which I'll get into in a minute. These are not new issues to many of you. We had debates about them throughout the fights over getting GINA passed, and we have, as you also may know, continued to talk about the importance of these terms and these definitions throughout discussions with the health insurance regulating federal agencies. So this may be a review for some of you, but we are emphasizing these issues with EEOC as well. Jeremy is going to talk about some issues related to the prohibition on employers requesting and requiring genetic information and the exceptions to that prohibition, which gets into really the nitty-gritty of where genetic testing pops up in employment. So Jeremy will be handling that, as well as talking about the need that we see for additional clarity on what's commonly known as the firewall. A provision in GINA which basically says that Title I and Title II claims have to be separated. So I'm going to let Jeremy handle those after I walk through the definitions. On this next slide, I want you to ignore the word underwriting, which should not appear there. That's my error. Underwriting was an issue in definitions for the Title I regs, but not for the Title II regs. But the definitions in GINA historically have been sort of problematic for policymakers to grapple with. And so some of our primary recommendations are that the agencies need to include specific examples of what are and are not considered genetic tests. The definition of genetic information, we feel, needs to include any genetic information no matter when it was discovered or obtained. So genetic information that an employer may learn about that was done before the employee came to that particular job, or even done before birth in the case of prenatal testing that might be in the employee's medical record. We want the regulation to make sure and be explicit that all genetic information is covered no matter when it was obtained. Other than that, one clarification, I think that the definition that the agency uses to describe what genetic information is quite complete. It includes genetic information that comes from the manifestation of a disease or a disorder in a family member, and talks a little bit about what a family member is. Any family history, as opposed to a genetic test result, is also included. So to talk about genetic tests for a moment, again, I think it's fair to say EEOC shows a good understanding of where we think the genetic test definition lines need to be drawn. The definition in Title II has one explicit exception to a genetic test. In general, a genetic test means an analysis of human DNA, RNA, chromosomes, proteins, or metabolites to detect genotypes, mutations, or chromosomal changes. There is an exception that states that the genetic test doesn't include proteins or metabolites that do not detect genotypes, mutations, or chromosomal changes, but we actually think that's more or less a restatement of what the rule itself states, rather than an actual exception that carves out any genetic tests. The GINA regulation does include some explicit examples of what is and is not a genetic test, and we think that EEOC got it right in their, to the extent that they lay out some examples of tests such as BRCA, variants, Huntington's disease, mutations. There are some examples offered of tests that are not genetic tests, such as viruses, tests for viruses, tests for drugs or alcohol that do not test for a genetic propensity, but simply test for the use of drugs or alcohol, or infectious disease transmitted through food handling. These are all examples of what would not be a genetic test. In our draft comments, we offer a lengthier list of tests that would be protected under the definition, and encourage EEOC to include our examples as well. To move on to the next slide, it's interesting to note that the concept of manifest disease doesn't really appear in Title II, but they have seen it as important to define what a manifest disease is. The basic idea behind GINA is that genetic test result is not a disease and therefore is treated not as a disease that could be medical information rather than genetic information. And I realize that's a little bit unclear. The issue here is that we want to be clear that a disease or a disorder or a diagnosis based principally on a genetic test should not be an exception to the definition of genetic information. So put another way, as it is put in the preamble, the mere presence of a genetic variant detected by a genetic test doesn't mean that that condition, disease, or disorder is present. In the context of employment law, if a disease, disorder, or condition is present with signs or symptoms, the Americans with Disabilities Act in most cases would provide the law for to what extent an employer could or couldn't take that condition into account. And finally, on the last slide, to talk a minute about the definition of genetic services, I think that the law itself actually is pretty clear. It explicitly includes testing, genetic counseling, and genetic education. The issue that we've tried to emphasize is that genetic services ought to include the services that people seek out on the basis of a genetic test that reveals that they're at an increased risk for a particular disease. While it's not explicit in the law, it is absolutely in the motivation behind GINA that patients need to feel able to pursue preventive care based on their genetic test results, and they should not have to fear that there will be discrimination on the basis of seeking that preventive care. So that's an issue that comes up both in Title I, where health insurers would have information about people's preventive care, and employment, where an employer might also have that information. So with that, I'm going to turn it over to Jeremy to shift gears and talk about some of the employment law related aspects of this rule.
Thank you, Susanna. As Susanna said, in terms of the EEOC's administration of Title II, they've already issued an NPRM, and that's largely the result of the fact that the EEOC, as compared to the agencies that administer Title I, has been intimately involved with GINA for many years. The EEOC played a major role, for example, in drafting President Clinton's executive order on genetic discrimination for protecting federal employees from genetic discrimination. So their background, they've also testified in Congress during the GINA process, so their background on GINA is far more extensive than some of the agencies administering Title I is, and as a result, I think we see a relatively well-constructed NPRM. There are some issues, though, that could potentially be significant that we address in our comments, and I, in particular, address the majority of my comments to the acquisition of genetic information section of Title II. What I'd like to start first, though, and this will refer back to some of my more substantive comments on the acquisition of genetic information section of Title II, and that has to do with some of the language that the EEOC uses in the preamble to the NPRM. In the preamble, as it's currently written, it states that with regard to the acquisition of genetic information, Title II restricts the deliberate acquisition of genetic information by employers or other covered entities. What we attempt to do in our comments is to nuance this language, because what Title II was meant to do was not simply to prohibit the deliberate acquisition of information. It was meant to prohibit intentional acts. The difference being that an employer, for example, under the acquisition of genetic information section, is prohibited from intentionally requesting, requiring, or purchasing genetic information. Now, that is an intentional act, but it's not necessarily with the intent of actually accessing genetic information. An employer, for example, may make a more general medical inquiry and may take no additional steps to inform a third party that that inquiry is not to include genetic information. That is still a prohibited act under GINA. GINA would prohibit that act even if there was no specific intent to acquire genetic information. By analogy, it's analogous in some ways to what some of you may know from a more casual understanding of the way our criminal law system works. In our criminal law system, the difference between a murder charge, for example, and a negligent homicide charge has to do with the intent of the person who commits the crime. There is no intent requirement in that sense in GINA. You either are acquiring information or you are not acquiring information. Whether there was an intent to acquire actual genetic information is irrelevant. And that's important because much of the efforts that we are seeing now in terms of what the employer community is seeking is an attempt, now that GINA has been passed, to prevent any type of changes that might require them to change current practices. So the average employers would otherwise respond by saying, well, of course we never specifically asked for genetic information. Well, that's not quite the point. The point is making sure that they change their practices to ensure that they are not acquiring genetic information as the result of other inquiries. So we felt it was important to state in the preamble that distinction. The NPRM goes through, just very quickly, the employment discrimination prohibitions. It's entirely consistent with the GINA language. It acknowledges that the GINA language on discrimination mirrors other federal discrimination laws, including Title VII and the Americans with Disabilities Act, and EEOC NPRM follows this quite closely, so we didn't feel any need to specifically comment on that section. The general rule that the EEOC uses for acquisition of genetic information in the NPRM is the same as GINA. It makes it an unlawful employment practice for an employer to request, require, purchase genetic information. And in that respect, they follow quite closely to the NPRM. In terms of the exceptions, though, to the prohibition on acquisition of genetic information, the NPRM, we feel, needs to be much more closely crafted. The most importantly, probably, would be the first exception, the inadvertent request exception. That exception, in the way that the EEOC currently describes it in the NPRM, leaves it open for a number of understandings that we feel are inconsistent with GINA. The exception was meant to address what we've so often called the water cooler exception, where an employer would accidentally overhear a modest conversation between employees. What the water cooler exception or the inadvertent request exception would not address, though, are situations where employers begin to ask more probing questions, where the conversation begins to take on a tone where the employer knows or should know the genetic information could possibly be offered. And in that situation, it's quite clear that the exception should not apply. And unfortunately, that nuance is not right now expressed in the NPRM. So it's important, we felt, to bring that up to the EEOC's attention. In addition, they make in the inadvertent acquisition exception in the NPRM, they make a distinction between certain types of medical inquiries. Of course, for example, under the Americans with Disabilities Act, after a conditional offer of employment has been made, an employer can acquire medical information about their employees or potential employees in this situation, even if it's not job-related. In those situations, the EEOC's NPRM is consistent with GINA, we feel, in the sense that it requires employers to take a proactive measure to make sure that they aren't acquiring genetic information. But they make a distinction in particular with another process that occurs under the Americans with Disabilities Act, and that has to do with reasonable accommodation requests. These are requests when an employee who is disabled approaches an employer and seeks a reasonable accommodation for their disability within the workplace. In these types of situations, the NPRM is currently drafted likens that type of a relationship to the inadvertent request exception in general rule, in the sense that the employer isn't specifically necessarily asking for this type of information. So if this type of genetic information is offered to the employer during a reasonable accommodation request process, the EEOC's NPRM believes that it falls within the exception. We do not. Reasonable accommodation requests are a very extensive process of interaction between employers and employees. And we feel that there is absolutely every opportunity during that process for an employer to take proactive measures to make sure that they are not inadvertently acquiring genetic information. So we believe, and we state so in our comments, that reasonable accommodation requests should not be subject to the exception and should be subject to the same requirements as any other medical inquiry would be under GINA. And we also reiterate a more general problem that we find with the NPRM, and that is that it is not particularly clear as to what proactive measures an employer actually has to take now under GINA in terms of their medical inquiries to make sure that they aren't acquiring genetic information. No specific language in the NPRM is offered, nor is the concept even particularly well addressed. So we felt in both cases to make sure to bring that to the EEOC's attention so that they could address that further. In terms of additional exceptions under the acquisition of genetic information section, has to do with an employer who offers health or genetic services to their employees. An employer who offers health or genetic services to their employees under GINA can acquire genetic information if an employee voluntarily offers that information as part of their participation in a wellness program, for example. The problem is how many wellness programs that are offered by employers are currently constructed, and how that interacts with the idea of voluntary under GINA. Many employer programs currently are incentive-based wellness programs. That means that the employer offers the employee some form of remuneration for their participation in the program. That can either be a direct monetary amount, or it can be any one of a number of other forms of incentives, everything from airline miles to travel awards to merchandise. And any program we believe that is incentive-based cannot be called truly voluntary. Particularly with the current state of the economy, few employees have the means to turn down the incentives that are offered through these wellness programs. And we feel that as a result, these wellness programs that are incentive-based are very much not voluntary, and we feel that should not fall within the exception. Additionally, even for non-incentive-based wellness programs, it's important that employees have control over the release of their personal genetic information as a result of participation. Many wellness programs, in fact some wellness programs almost entirely, are comprised of what are called health risk assessments, which are often lengthy questionnaires that ask employees a whole host of questions, including questions regarding family history. We believe that the voluntary requirement would not be met if an employer requires, as a result of participation, filling out the family history sections of a health risk questionnaire. So we felt it was important to bring to the EEOC's attention and note that either the questions on a health risk questionnaire should that address genetic information should either be removed entirely or that they should be made voluntary as far as an employee's need to fill out those parts of the questionnaire in order to maintain the voluntary requirement under the program. An additional exception under this general rule on acquisition of genetic information has to do with commercially and publicly available information. That employers who, for example, might pick up a newspaper and happen to read an article that dealt with the genetic information of their employee wouldn't necessarily be responsible under GINA for that acquisition. And that was the intent of this exception. The EEOC has, in their NPRM, offered to expand that definition to include electronic media. We felt that generally that was sufficiently within the intent of the Act to do, but we felt that the framework for which the EEOC lays out this exception needed to be rethought. The exception, for example, under GINA currently does not include things like medical databases and things like court records. Even though medical databases and court records can often be public in terms of the general public's ability to access that type of information. So we felt it was important to bring to the EEOC's attention that this exception was not meant to utilize a public versus private framework in terms of what is available under the exception and what is not, but rather that the exception was meant to apply to mediums that were a heightened risk for containing genetic information, regardless of whether they were public or private. And that list could be quite extensive, and it could include everything from legal databases to members-only websites to internet-based chat rooms, professional trade materials, and the like. But that it was important to make sure that that distinction was made in this exception. An additional exception has to do with genetic monitoring in the workplace. Under GINA is a departure from the traditional law in this area. On the Americans with Disabilities Act, for example, has what is called a job-related standard for disability inquiries. That means that if an employer can prove that a medical inquiry of a current employee is somehow job-related, they can continue with that inquiry. In terms of genetic monitoring, GINA is a departure from that standard because GINA does not allow an employer to conduct genetic monitoring of an employee unless the employee voluntarily complies, even if the employer might be able to meet a job-related standard of proof. GINA does not allow for that. So the question that then arises, of course, which is not addressed in the NPRM, and we feel it's essential that it must be, is what steps an employer can take if an employee fails to give consent to testing. Can the employer remove the employee from the location that they're working to a separate location? If so, what changes can they make to make sure that that they are not interfering with the discrimination provisions of GINA? Whether whether they can make any modest salary changes as a result of changing their location, or any of the other type of changes that might occur when you move an employee from one location to another. We felt that the NPRM needs to address this possibility so that employers who are faced with the situation of an employee who doesn't voluntarily consent to genetic monitoring for toxic substances in the workplace, that they have a framework for acting. There is another exception having to do with law enforcement and human remains quality control purposes that I think Susanna might address quickly.
Sure. This is an exception that was added in the final weeks of deliberation over GINA, which provides, basically allows law enforcement or human remains laboratories doing genetic testing as part of their work to continue what is essentially a quality control practice of testing their employees for a limited set of genetic markers in order to be able to identify contamination problems with the samples that they are processing. So we think this is a legitimate version of genetic testing that's not going to implicate an employee's health risks for the future. And in our comments, we recommend what is the right sort of process to use genetic testing in this way, that it should be a limited set of markers that don't include health-related information. The employee's DNA sample should be destroyed after a designated period of time, and the sample and the results should be kept for quality control, not for any other purpose. And as with all the other exceptions in this area, to the extent an employer does obtain the genetic information, does acquire it, that information still may not be used to discriminate and has to be kept confidential.
And finally, our comments address the firewall between Titles 1 and 2 of GINA. And for those of you who aren't familiar with the firewall, essentially, and this came rather late in the development of GINA and was really the last essential negotiation that led to the passage of GINA. And the intent of the firewall is to, or at least ostensibly the intent of the firewall, is to create separate causes of action for claims under Title I and Title II, so that a claim arising under either title would be addressed within the title, and that you could not engage in what is often the case in civil litigation, the kitchen sink approach, so where you would essentially sue everybody as a result of a claim and let the court figure it out. In this type of situation, a claim under Title I, according to the firewall, generally would be brought against an insurer with the remedies that are available in Title I, and the claim under Title II would be brought against an employer with the remedies that are available in Title II. And what the EEOC and the NPRM made sure to clarify, which was a source of potential concern for us and was alleviated by the NPRM, was to make sure to note that an employer is not immunized from liability under Title II when they make an employment decision based upon information that is protected under Title I. This would be a situation where, for example, an employer, which is probably one of the most likely situations where an employer would discriminate, and that is where an employer would discriminate based upon health insurance information derived from a health insurance inquiry or that arose during a health insurance situation. And an employer who's made an adverse employment decision based upon that type of information under the NPRM is liable under Title II and has the remedy, and a claimant would have the remedies available under Title II in pursuing such a claim. So that is a good thing. The one thing that the NPRM does not address, and we felt was important to note, were situations where an employer would engage in an act that influences an entity under Title I to take an adverse action. So, for example, and this would largely be situations where you would have large employers, employers who have significant financial advantage within their relationship with their insurance companies, who might put pressure on the insurance company to make an adverse decision. The NPRM doesn't address that situation. And in that situation, the actual decision would be made by the insurance company and therefore be governed by Title I and the remedies under Title I. We felt it was important because we believe that it's within the keeping of the intent of GINA that an employer who attempts to influence an insurance company, for example, to make an adverse decision, that they should also, the employer, be responsible for under Title II for engaging in an act that was discriminatory under Title II. So we felt it was important to address that type of situation. With that, I can end my general comments and open this for a discussion and questions, and we welcome any thoughts that you have.
Okay, great. Thank you so much, Jeremy and Susanna. That was a wonderful overview, and I think it inspired quite a few questions on our end. And so I'll try and weed through those. Some of them, there are quite a range of them, so we'll try and kind of take a stab at them as much as possible. Let's see here. In particular for employer-based coverage, let's see here. There was some confusion expressed by a couple of participants with regard to, and I think it has to do probably a little bit with that firewall piece, so we'll start there, with regard to exactly the interaction with GINA between Title I and Title II with regard to when you're receiving insurance through your employer. If you can just try and give sort of a brief overview of exactly how that interaction works, I think that would be helpful for our participants.
Sure. You know, I think it's probably fair to say that with the exception of the kind of extreme circumstance that Jeremy just laid out, where an employer that is providing health insurance attempts to influence the health insurer, for the most part, any health insurance that you are receiving through your employer is governed by Title I of GINA. The employer may be the administrator of the health plan directly or indirectly. It may be paying some portion of your premiums or not. But it is the health insurer doing the underwriting to determine the premium costs that is regulated by Title I. Title II, for the most part, deals with hiring decisions, firing decisions, promotion, training, those sorts of decisions. What we wanted to do, and what I think Jeremy did a nice job of doing, is lay out the possibility that an employer could use sort of as a stick the benefits that it provides in some way. But that is, I think, more a consideration for who you would sue rather than what law applies immediately. So to put it maybe more simply, whether you get your health insurance through your employer or not, GINA means that the health insurer cannot discriminate against you on the basis of the genetic information, and Title I is the law that applies.
I would add that this, the distinction between Titles I and Title II comes down to who is the decision maker and what is the decision. If the decision maker is the insurance company making a decision about regarding your health care coverage, whether or not that company provides that coverage through your employment, that is governed by Title I. If the decision maker is the employer making a decision about any number of issues regarding your employment relationship, hiring, firing, promotions, etc., that would be governed by Title II. And then, of course, who is in terms of acquisition of information, the same distinction applies. Whoever is acquiring the information would depend on which title governs.
Okay, great. Thank you so much, you two. One question that I do have from the audience with regard to the Notice of Proposed Rulemaking, there's a mention in the NPRM of retaliation or an anti-retaliation provision in Title VII of the Civil Rights Act. Can you two just really describe how that applies to GINA? And Jeremy, I think we're still getting just a few volume problems on our end, so if you could just be sure to speak into your mic, I think that'd be helpful.
Sure. GINA, the employment provisions in GINA, aside from the definitions, which are relatively quite new to employment law, the bulk of the provisions in Title II of GINA are consistent and mirror existing civil rights law. So many of the provisions that you would have in Title VII and the Americans with Disabilities Act, Age Discrimination and Employment Act, and others are present in GINA, and the retaliation provision is one of them, meaning that, and generally, if an individual, in this case an employee, brings a claim under GINA against an employer, that employer is barred from taking any adverse employment action as a result of that employee pursuing that claim. That's a relatively common standard within civil rights and employment law, and it is present in GINA as well.
All right, great, thank you. And then one question I think really was brought up with regard to public versus private information, and kind of thinking about social networking and how information is shared now. Because more and more employers and their employees are on Facebook, can you maybe almost even use, I guess, use Facebook as an example of how, or I mean, there's Facebook, MySpace, and then you can go down another spectrum with sites such as Patients Like Me or other ways that people kind of organize and share information that might have that already kind of idea that genetic information could be shared on one site versus another. But could you be a little bit more specific in terms of talking about social networking sites, especially because I think that was a particular area of concern for some of our participants.
Sure, and the intent in this comment is to make sure that this exception, the exception for commercially and publicly available information, is read in a limited fashion. In fact, that's sort of the idea that runs through all our comments on these exceptions, is to make sure that these exceptions are, as intended, read in as limited a sense as the drafters intended. As many people are, I'm sure, aware, exceptions can often swallow the rule if they're not crafted carefully. And we felt that it was important under this exception for commercially and publicly available information to make sure, particularly because it includes electronic information, that the type of information that an employer could acquire was not protected by this exception, was not limited just to information that was entirely private. And by analogy, we address two specific areas that are actually found in the GINA language. GINA specifically prohibits medical databases and court records from the protections of this exception. And the reason why they did that is because medical databases and court records are areas where the employer knows or should know have a heightened risk of having genetic information within them. Well, by extrapolation, we believe that that same rule should apply to all mediums, that regardless of whether the medium is potentially available to the employer publicly, that doesn't mean the employer should be using it as a tool for acquiring information. And in terms of the employment context, we felt it was important to include things like social network sites and areas where an employer might troll for genetic information or other forms, frankly, of information that they might use in the employment context. Generally, that's become, or it's becoming often regular practice among employers to start looking for alternatives when they are making inquiries about their employees to sort of the more traditional reference checking. And we've already seen many instances of employers trolling for information on the internet and in other areas where it might be publicly available for private information about their employees that may not have been offered to them through more traditional channels. We believe that the language in GINA clearly prohibits that type of inquiry, and we felt it was important to make that distinction in the model comments.
All right, great. So a couple of these, this next question here is more with regard to, I guess I would say the definition of genetic services and really how that applies with more conversations with health professionals. The first is kind of a detailed question. How do you feel that genetic counseling, in your model comments, you specifically refer to genetic counseling either from a counselor or from a doctor. But genetic counseling is available in a couple of forums. I mean, right now with, nurses are available to provide genetic counseling as well, or at least provide education surrounding a similar, in kind of a similar vein. Do you think that that is something that we need to keep in mind, especially with genetic counseling, that we're able to keep it broad without unintentionally creating any barriers?
It's certainly true that genetic counseling increasingly is and has to be done by a wider range of health professionals, simply because genetic testing is becoming more common and there just aren't enough certified genetic counselors to do the work. It's just, I think, a fact of medical practice. I don't think that affects the way genetic services should be interpreted for purposes of GINA. The idea here is that GINA is setting out to prohibit the employer, in this case, from discriminating based on something that they learn about the employee. The easy case to imagine is the employee has a genetic test result, and that is what the employer learns. But I think that the definition of genetic services and the inclusion of genetic counseling basically stands for the idea that if an employer learns that an employee has sought genetic counseling or sought genetic services or had genetic counseling or had genetic services, that there can't be discrimination on the basis of that fact. So the assumptions that an employer might make about whether an employee knows or believes that they are at risk for future disease, and that's the basis of the genetic counseling or whatever, the discrimination can't take place because the employee has had that genetic counseling. And I don't see a reason why you would want that definition, I think. I do think you would want that definition to be broad.
All right, wonderful. I guess a lot of our remaining questions are with regard to existing resources that are out there, or resources I think that even would be of interest to people in developing. Could both of you possibly elaborate on any, rather than having you right off the cuff explain the kind of correlations between GINA and ADA and that relationship, and you're certainly welcome to elaborate on that now briefly, or however you can briefly, but also with Title II and GINA and HIPAA, can you suggest any resources for our participants in wanting to learn more about those interactions?
Well, one thing that Jeremy and I have talked about doing over the next couple of months is creating some fairly straightforward resources for essentially aimed at employees, what you need to know about genetics and genetic testing and employment, which I think will help to synchronize some of those issues. And I'll let Jeremy talk maybe specifically now about whether there are resources that are out there in particular. But I do think that whether you're applying for a job or considering applying for a job somewhere, or genetic testing comes to your workplace in the form of a wellness program, there are a number of issues to be aware of. So I realize I'm not answering the question with resources. You know, I think all of us want to make sure we know what the law is. Now that we have the NPRM, we have a pretty good sense of where we'll end up, but it's obviously not final yet. So in terms of resources on the ADA, the EEOC does have a number of guidances and other documents on its website that I think are useful.
I would join Susanna in suggesting that anyone who's interested in learning more about the ADA in particular, that they do use the EEOC's website. They not only have quite a number of more general documents, but they have some quite extensive question and answer sections on the ADA, as well as other civil rights laws as well that that listeners might be interested in. So I would suggest going there. Just to be clear in terms of, you know, GINA and the ADA and the way they might interact more, you know, generally, you know, many of the same language is employed throughout both in order to keep them consistent with each other in terms of how they might be used, and generally GINA, of course, addresses situations where an individual is being discriminated against before there has been any manifestation of the underlying condition that might be associated with the gene. Once there is manifestation, ostensibly the ADA applies, although it's clear that there remains a group of individuals who could potentially be discriminated against because they have a manifestation of a disease who would still not be protected under the Americans with Disabilities Act, because that manifestation doesn't necessarily rise to the level that the definition of disability under the Americans with Disabilities Act entails, in which case there is still, of course, work to be done here to fill the gap between GINA and the ADA for those individuals. Nevertheless, that's generally the framework that we're faced with.
Okay, great. And then we just, one more real quick brief question, and then we'll wrap up. Is GINA retroactive for someone who lost a job due to a diagnosis in the past couple of months, or even due to I would extend that even more to due to an employer firing an employee because of finding genetic information? Is it retroactive?
No, it is not retroactive, and in fact, you know, GINA hasn't even gone into effect yet. So somebody who was discriminated against today would still not have the protections of GINA until it actually goes into effect. Susanna might remember the exact dates, but I believe the Title I goes into effect later this year and Title II in the middle of next.
Well, Title I is a little bit confusing, but essentially we are supposed to have Title I regs in effect soon after May 21st of this year. Now, given that we don't have a regulation yet, it's not clear whether they're going to make that deadline or not. The Title II regs are going to be in effect November 21st of this year. Jeremy, can you comment, though, because this is not my area of expertise, on if somebody believes that they have been have lost a job or been discriminated against on the basis of genetic information? I mean, there are certainly other possible avenues. The EEOC, for many, many, many years, has said that the ADA includes genetic information. That's obviously an area of law that's somewhat in flux now.
Well, that's true, although in large part it was the lack of belief that that EEOC recommendation had any validity with the courts that led to the employment provisions in GINA, maintaining the employment provisions within GINA. So that's, of course, a possibility. I think a more likely potential avenue for legal redress might be a situation akin to what happened with Burlington Northern Railroad, which was one of the cases that, of course, drove the enactment of GINA, and that had to do with the job-related requirement under the Americans with Disabilities Act. Under the Americans with Disabilities Act, in terms of current employees, you cannot, as an employer, acquire medical information unless it is job-related. And that is a very specific standard that for which there has been plenty of case law to define. In a situation where an employer might be acquiring genetic information where it is not job-related, which would be, frankly, many situations, if not most situations, where an employer might try to acquire genetic information. The fact that they might, want to save money on their health insurance would not meet the job-related standard, certainly. Then they might have redress under the ADA, and I would certainly suggest that they do so. And GINA, by the way, does not prevent multiple claims to be brought under different acts from the same discrimination claim. So an individual could bring a claim under both GINA and the Americans with Disabilities Act if the circumstances of their claim were addressed by both acts. So that's also a possibility.